The plaintiff in this case is Braxton Lee Banks, who at the time was a running back for the University of Notre Dame, and the defendant was the National Collegiate Athletic Association, also known as the NCAA. The volume number is 977 and the page number is 1081. The reporter of the case is Federal Reporter 2D. The court in which the case was decided was in the United States Court of Appeals for the Seventh Circuit. Lee only played 3 of his years in college due to injuries and sat out his senior year. However, upon returning to play his 5th year that he was eligible for, he was denied playing time due to NCAA rules 12.2.4.2 and 12.3.1, also known as the no draft and no agent rule.
After an injury, Banks signed an agent and entered the NFL draft, but was not drafted. Banks filed a claim against the NCAA rules which states that Banks forfeited any future college sports eligibility after signing an agent. Banks filed suit contending that the NCAA no draft and no agent rules were violations of the antitrust laws under the Sherman Act. Claims that the NCAA terminated the athlete's eligibility after signing an agent is direct violation of illegal restraint on trade. Banks could not prove the violation of the Sherman Act, and therefore the case was dismissed. Did the court's findings find restraint on trade in the market, and did Banks prove this? The plaintiff, Banks, did not prove the NCAA rules to be a restraint of trade violation of the Sherman Act, specifically the no draft, no agent rules. Banks failed to prove no agent, no draft rule diminishes terms of employment and competition in the employment market. The review of Banks' amended complaint reveals that he alleged that college football players are regulated under terms of employment or that players are selling the services to their colleges. Because he could not prove this, the case was dismissed.
The example that the plaintiff Banks provided was the fact that the NCAA's rules and regulations were much too restrictive and they were keeping better college athletes out of the NFL and keeping them in the NCAA programs, which were already profitable. However, the court concluded that Banks had no antitrust injury and that his argument failed to make any real impact on a relevant market. In conclusion, the examples were not enough for the court to reverse its decision in Banks' situation. The court's main reasoning for its holding in Banks' situation was the fact that collegiate athletes should not be able to return to NCAA competitions with professional experience. This is experience that Braxton had through the NFL Combine as well as having an agent. He saw the expectations of professional scouts as well as how you should behave around the professional environment. This experience voided Banks' eligibility to participate in collegiate competitions. The court also decided that the injuries that Banks suffered were not sufficient enough to allow reversibility to the rules of the NCAA. As a quick summary of the case, the court believes that Banks' decision to sit on the bench was a personal decision, and not one that was mandatory. Also, the main holding behind the court's decision was the professional experience that Banks gained by participating in the NFL draft and having an agent represent him. Also, the NCAA rules and regulations are there to keep the competition fair in collegiate environments to prevent any professionals or those with any professional experience of entering the market or competitions.
In the court's finding, the NCAA states that it would be a sham to dismiss this rule, turning college football from educating the student athlete to creating a minor league farm system out of college football. The NCAA goes on to state that we should not permit the entry of professional athletes and their agents into NCAA sports because the cold commercial nature of professional sports would not only destroy the amateur status of college athletics, but more importantly would interfere with the athletes' proper focus on their educational pursuit and direct their attention from the quick buck in pro sports. Therefore, the NCAA states that it would be a sham to dismiss these rules in favor of Banks.